This video is brought to you by Against the Flow of Mississippi. Against the Flow of Mississippi is a book about Jake Fayard, a Marine veteran who is unhappy with the political machine running the state of Mississippi. He decides to fight the corruption from the inside. Jake will face more challenges than he ever has and will stand up for what he thinks is right. His notoriously hot temper will push him to the edge of murder, along with his friend and brother Kobe Barhanovich. Together, they will fight the system and give the power back to the citizens of Mississippi. Against the Flow of Mississippi is now available on Amazon. A link to the book will be placed in the description below.
All right, y'all. Anthony Allen, your host, Beyond Count, Life on the Compound. I am joined by
Delmas White.
And we are going to discuss my lawsuit that just got dismissed against the state of Ohio. Now, I asked Delmas to join me on this because he is fixing to be a law student at Ole Miss, and he just got accepted, so congratulations.
Thank you.
Maybe you move up and, switch over to Tulane.
Yeah. I'm thinking about it. A lot of people recommended it.
Anyway, Delmas has been looking at legal documents for a while, and he's got a lot of lawyer mentors here on the Mississippi Gulf Coast that have been training him very well. And we just read the judge's decision to dismiss my case. The judge's name is Lisa Sadler. The magistrate's name is Adam Morris, and this was the Court Claims of Ohio. So, what'd you think?
It was a slap in the face, nonetheless. The brief goes down, I think, in my opinion, a whole matriarchal of we care about our prisoners more than we care about our employees. And that's completely backwards in regards to public trust and workers' confidence in the institution that they're at.
I agree with that. Let me tell y'all my assessment of the state of Ohio as a whole. And I'm talking about the Department of Rehabilitation and Corrections. I'm talking about the Court of Claims. I'm talking about the Ohio Highway Patrol, who investigates claims on state property, crimes on state property. I'm going to tell y'all what I think. I am of the opinion that they don't give a damn about COs. They don't care about us. If you still work for the Ohio Department of Rehabilitation and Corrections, this shows that they do not care about you.
This should be your notice. This is a manifesto of how they deal.
We're going to break down exactly what they said. This is going to be a long-ass video, just to let y'all know. But we're going to go point by point on what we got. Can you see the screen all right?
Yeah. Mm-hmm.
Okay. I can make it a little bit bigger if it helps.
Yeah, just a little bit.
All right. Y'all excuse me a second. We're going to do some computer stuff here. Sorry, they've changed some things on Adobe Acrobat Reader on this one for some reason, and I don't understand why, but I couldn't find my Zoom, and yeah. Anyway, so it starts out, on October 31st, 2024, defendant filed a motion to dismiss plaintiff's amended complaint pursuant to Civil Rule 12B1 and 6, which has been fully briefed. However, on November 13, 2024, without leave of court, plaintiff filed two replies entitled Response to Defense Response 11/12/2024 and Response to Defendant's Response 11/13/2024 respectively. Because plaintiff did not obtain leave to file either cert reply, neither will be considered by the court. LCCR 4C, and I still have not found out what LCCR means, so I couldn't look that up to find out all the rules of that. I'm guessing it's some kind of civil review or civil rules or whatever. Additional briefs may be filed only upon showing of the necessity, therefore, and with leave of court. For the following reasons, the defendant's motion to dismiss has been granted. Let me explain why I filed my responses. I thought I was required to file a response because they sent one in response to their motion to dismiss. They sent additional arguments after I responded, so I responded to their additional arguments. Isn't that how a debate works? I mean, I'm not a lawyer. You know far more than me, because I don't pretend to be a lawyer.
And what really sticks out on the first part of this motion, they put granted in complete uppercase.
Well, that's
so they to me that just shows that
no. That's how you do. That's how you file this. That I understand. That's how they're supposed to do that.
That's the first time I've seen this on a
No,
document.
no. They do that. That's common. I've looked at several other cases that have been filed in this court, and that's how they put their their court stuff. But I'm talking as far as the responses. Mm-hmm.
Normally there's an open line of communication, especially something like this, or any case review between plaintiffs or defendants.
Right.
Yeah.
And the sad thing is I couldn't find any lawyers in Ohio that had the balls to take this case. And I'm just going to put it out there. It's not willing to take the case. I guess they didn't have the stomach for the fight that I was ready to put up, so I put up my own fight. And by the way, just to let y'all know, this ain't over. I'm not done. I may be down, but I'm not out. And I will be appealing this to federal court. That is my next step, is federal court. And I will be filing it in the Southern District of Ohio. I'm not playing. That is my next step. But let's go ahead and scroll down here. Let's see, we got standards of review. The standard of review for a motion to dismiss for lack of subject matter jurisdiction pursuant to Civil Rule 12b-1 is whether any cause of action cognizable by the form has been raised in the complaint. And it quotes state. I'm sorry, I'm not a lawyer, but it quotes a case.
Yeah. State. What is it?
State Bush versus Spurlot, 42 Ohio, whatever. 1989 case, it looks like they're quoting here. Subject matter. Okay. The subject matter is there was negligence on behalf of a state agency.
Right.
That was my subject matter. The Ohio Court of Claims is supposed to handle that. So I think that's a mistake. When considering complaint against a Civil Rule 12b-6 motion to dismiss for failure to state a claim, I did state a claim, the court must presume that all factual allegations of the complaint are true and make all reasonable inferences in favor of the non-moving party. For a court to dismiss a complaint, it must appear beyond a doubt that the plaintiff can prove no set of facts entitling him to a recovery. Let me tell you what I sent the judge. I sent the judge a link to all 3 videos of the assault. I sent the judge the assault packet. Obviously, I was assaulted, and obviously, the fact that the inmate has not been criminally charged with assault on a correctional officer speaks for itself, does it not?
Absolutely. It does. And it shows you where the state stands on pretty much, I mean, you can go through a level of things, and it completely just falls into their face of how they handle matters such as this. It's disgraceful. And the videos, to mention, were from body cam footage and also personal photos as well, displaying what the inmate did.
Well, this procedural history and factual background. On November 7th and 8th, 2024, plaintiff filed miscellaneous documents as exhibits in support of his response to in opposition to defendant's motion to dismiss. However, in reviewing a motion to dismiss for failure to state a claim, a trial court may not rely on allegations or evidence outside of the complaint. Actually, if I say that I was assaulted by an inmate and the inmate was not criminally charged, as I still maintain the state has a duty to do, not just a privilege, not a right, a duty, an obligation, and I show you the assault packet in the videos, how is that outside of my claim?
I can't find a way outside of that claim, specifically with that hard evidence that's already been presented. Once again, it betrays the public's trust. They have an obligation,
Right.
at the end of the day, to protect their employees while also maintaining some level of order within their prison system. And it shows they don't care at all about that or the rules of law.
They don't. Upon review, these miscellaneous documents were not attached to the amended complaint. As such, court shall limit its consideration to only the 4 corners of the amended complaint. Let me tell you why these documents were not attached to the complaint. I didn't have them. I didn't have the videos until a couple of months after I filed. The state had them. I didn't have the assault packet, the unredacted assault packet, by the way. See, here's the thing. I asked for an assault packet, the assault packet. There was a lot of redacted information. I got the unredacted. I'm not going to tell you. I'm not going to say how, but I got the unredacted assault packet. But upon review, these miscellaneous documents were not attached to the amended complaint. As such, the court shall limit its consideration to only the 4 corners of the amended complaint. I would argue that this is within the 4 corners because it shows what happened. It looks like lawyers are trying to out-lawyer me. But that's okay. That's fine. Because we all know the truth. And I know a lawyer, and by the way, I want to go ahead and put this out there. I am not upset with the attorneys that were representing the Department of Rehabilitation and Corrections. I spoke to 2 of them. I spoke to those 2, and they were very nice. They're good lawyers.
They were doing their job.
They were doing their job. They were zealously representing their client. So, 0 complaints on them. They did everything they did everything that they were supposed to do. So kudos to them. I'm glad they did their job. Unfortunately, it was against me. But unfortunately for y'all, I'm not done. So we will be talking again. Accordingly, presuming that all factual allegations in the admitted complaint are true and making all reasonable inferences in favor of the plaintiff, the admitted complaint sets forth the following relevant facts. This case derives from defendant's alleged failure to properly respond to an August 14, 24 inmate assault on plaintiff, a former correctional officer, with the defendant. And it quotes me in the complaint. It says, I was a correctional officer at Toledo Correctional Institution. I was assaulted by an inmate who threw fecal matter and other unknown fluids on me during feeding dinner. I informed the captain on duty and the institutional investigators that I wanted to press outside charges on the inmate. I was given every excuse why no charges could be filed, all of which was determined to be a lie. I quit my job with the department on September 5th, 2024 due to feeling unsafe at work. Yes, I did. I absolutely did. Plaintiff was employed by defendant at his Toledo Correctional Institution from June 10, 2024 until September 5th, 2024. Plaintiff is an experienced correctional officer with several years of experience in other states, but was fresh from training from the Department of Rehabilitation and Corrections and was not completely familiar with many of the policies. That is true. These are all from my original complaint. On August 14, 2024, plaintiff was staffed to B34 South Housing Unit, assigned a partner with limited experience in corrections. There were no senior officers directly assigned to the housing unit. Such housing unit houses inmates who are violent or with a history of serious behavioral issues within the prison system, many of them violent, or are prone to violence against staff and correctional officers. At the start of his shift, plaintiff made the decision to enforce the institutional rules completely in the housing unit after an earlier medical emergency. That is true. Subsequently, inmates repeatedly disregarded plaintiff orders, and he received multiple verbal threats from several different inmates throughout the shift, which I did. Plaintiff was later tasked as a contact officer during dinner, which required him to unlock the flap of the inmate's cell, issue the meal tray, and secure the flap once completed. One inmate acted very confused, that'd be inmate Lore, by looking at his tray and was evasive when I asked him if he was refusing his meal. Plaintiff looked away momentarily to check on his partner. Upon looking back, the inmate discharged a container filled with human feces and other unknown liquid substances onto plaintiff's person. That is true. Plaintiff was hit in the facial area, mouth, head, upper torso with these substances. That is true. The video is on here. A call was dispatched for an officer assault, and plaintiff was ordered to report to the ship's office to speak with captain. Plaintiff gave a statement to the captain and insisted he desired the inmate to be charged with outside crime of assault on a correctional officer. Plaintiff was offered a shower in medical, given a change of uniform in order to return to duty in the same housing unit, but after shift reported to the emergency room for post-exposure medications, which I did. That is true. Plaintiff spoke with two in-house investigators regarding his desire for outside charges to be brought against the inmate, and both the investigators informed plaintiff that they would look into the matter, but cautioned that the Lucas County prosecutor would not charge or prosecute the inmate if he had more than 5 years left on his sentence. That is true. That is what I was told. Plaintiff followed up with the in-house investigators and learned the Ohio State Highway Patrol investigator had yet to review the incident. That again is true. Plaintiff instead contacted the Ohio State Highway Patrol investigator directly, who, after receiving the paperwork from the in-house investigators, that's not entirely accurate. The only reason he got the paperwork was because I called him and he called the prison to get the paperwork. Let's not leave that out. Declared that he would not be able to investigate due to the criteria set forth by the Lucas County prosecutor in the alleged 5-year rule. Plaintiff subsequently drove to the Lucas County Courthouse and spoke with the prosecutor with the Lucas County Prosecutor's Office, who denied such policy existed. Yes, that would be Mark Hanhus. Plaintiff states that only institutional discipline has been taken against the inmate involved. Law and analysis. Plaintiff ultimately alleges that failure to prosecute the inmates for outside charges will create a dangerous trend that will cause more staff assaults in the future if inmates are not prosecuted for these actions and the investigators are not compelled to act in a proper manner. This is true. I said this. I stand by this. Plaintiff seeks institutional change as well as compensatory damages. Defendant asserts that the court should dismiss plaintiff's amended complaint in its entirety because court lacks subject matter jurisdiction over workmen's compensation claims because they are preempted by statute. Plaintiff failed to state a claim for intentional infliction of emotional distress because the alleged conduct is not outrageous as a matter of law. Huh? And 3, plaintiff failed to state a claim for negligence because defendant has no duty to ensure criminal prosecution of incarcerated persons for staff assaults. Okay, let's stop right there. Plaintiff, or the department has no obligation to defend correctional officers, protect correctional officers, and prosecute convicts for assaulting correctional officers. Okay. I will capitulate on one thing only. They cannot prosecute. No more than the police officer who arrested these convicts can prosecute them for whatever crime they arrested them for. Whatever felonious crime they arrested them for. But how does a cop arrest somebody for a felony on the street and that person go to prison? How do you get from step 1 to step you're locked up? How would that happen? How would that happen, brother?
Simply doesn't really.
Oh, it does.
Well,
because you go from, you commit a crime.
But there's an order of things, and the fact that.
But hold on a minute. Let's look at this, okay? So, I'm a police officer, and you're a convicted felon who's driving drunk with a pistol on your person. How do you get from me pulling you over to you actually being sentenced and going to prison? What's the steps? I'm going to pull you over. I'm going to do an investigation. I'm going to find out that you are a felon in possession of a firearm.
Right.
Drunk driving gives me the right to pull you over because you're swerving all over the highway acting like a dumbass. Okay. Now, how does it go to the prosecutor? The prosecutor didn't pull you over. The police did, right?
Right.
So, what happened? Isn't there a report sent maybe to the prosecutor?
Yes, there's a report.
Maybe an arrest report, maybe an incident report of some sort.
Right.
And that gets forwarded to the DA's office, right?
Yes. And all charges are brought upon.
Don't don't you think the investigators at the prison might have a duty to at least do that first step there?
No, absolutely. That's part of their job.
Oh, that's what I thought.
They have a responsibility, and the fact that they have done it sets a dangerous precedent for the entire system there.
Right.
It sets a very dangerous precedent because that basically is telling the inmates that they can do whatever the hell they want to.
Right. So, if I'm the cop and you're the convicted felon driving drunk with a pistol on you, and I pull you over, and let's just say I find the pistol on you, I know you're drunk, and I just say, all right, man, I'm going to write you a ticket for careless driving. You have a nice night now.
Even that person is an absolute liability to the public.
But have I done my job? Have I earned my paycheck? That's what I want to ask you.
Yes.
If I do that, if I let you go, you're drunk driving and you got a pistol on you and you're a convicted felon, maybe you do, maybe you don't have bad intentions, I don't know, but I let you go.
If you let them go and give them a warning.
Have I earned my paycheck? Have I done my diligence to do my job?
Oh, no. Well, no, you haven't done your diligence, but you just want to, be a sleazy officer. You've done your job.
No, I'm talking about do it the right way.
Oh, yes. Yeah. If you do it the right way, yes, you've done your job. Yeah.
See, I've kind of got this pet peeve about doing shit the right way. There's a right way to do things, and there's a wrong way to do things. Well, let me back up. There's only one right way to do things. There's a million wrong ways to do things. What's the right way for me to handle this situation? I'm the cop and you're the drunk driver that's a convicted felon in possession of a firearm. What's the right way you think I should have handled that? The proper way?
Pull them over, of course. Get their information.
Mm-hmm.
Look it up, find out what their history is, of course, and get them the hell off the fucking road.
Alright. And if I find out they're a felon in possession of a firearm,
you need to send that shit straight to the DA's office.
Right. I'm going to go ahead, I'm going to arrest you.
Yes.
I'm going to take possession of your firearm that you ain't supposed to have. Mm-hmm. I'm going to take you down to the Harrison County Jail and, let you get booked and released because we have a weak-ass sheriff here. But, another story. Do shit the right way. They didn't do shit the right way. So I did it my way. I took matters in my own hands.
Shows complete negligence.
Now,
I'm more pissed off because my major is in public policy, my bachelor's, and this is not good policy making. This is very sloppy job, and I know if I was Attorney General, this would be completely different. We will back the people that are maintaining society, not tell them to go fuck themselves and dismiss their motion. Yeah.
I'm telling you, if I got these arguments in front of a jury, which I don't think the Ohio Court of Claims has jury trials, but if I was to get this in front of a jury, I'm fairly confident that I would win. I'm also fairly confident that I'd probably get some punitive damages out of it too. Mm-hmm. Simply because the jury, if I show the jury the video, which is on here by the way, of me getting shit thrown on me, I'm fairly certain that right there would be enough to persuade them that, yeah, this is wrong. Where was I at? Plaintiff argues that the court is specifically set up by the Ohio Supreme Court for the purpose of righting wrongs done by agents and or agencies of the state. The basis of this grants the court jurisdiction that is required to judge this case, and I think fairly. Yes, I did say that. Alright. Now we're going to go subject matter jurisdiction, workers' compensation. This is not, and I repeat, once again for the cheap seats, Your Honor, once again for the cheap seats, y'all, this is not a workman's comp claim. This is a negligence claim. Mm-hmm. I've never once said, I mentioned that I was denied workers' comp, but I don't care. I was out for an 8-hour shift. I don't care about the 8 hours that I was not at work. That doesn't bother me. My vacation time took it up. I don't really care about vacation time because I was reaccumulating that anyway. And let's face it, Ohio is a boring ass state with nothing to do anyway. Mm-hmm. So the only vacation I would take would be to come down here to the real world where things make sense here in South Mississippi. I wouldn't be up there doing any vacation time. What I'm going to do? Go ice skating or something?
Do meth. It's fucking Ohio.
You're not wrong. You're not wrong. You're not wrong. A lot of dope and dumbasses in Ohio. Of course, I could say the same thing about around here too. We got a lot of dope and dumbasses around here.
At least we got a beach.
We do have a beach, and we do have the best food in the world.
Yes. Plenty of amenities.
Shout out to the Project Lounge for the steak sandwich I just got tonight. On point as usual. Anyway, moving right along. Plaintiff states that he was denied his claim of workman's compensation by defendant as well as his union for his time spent after work in the emergency room. Yeah, I did say that. Defendant argues to the extent that plaintiff seeks work compensation for his workplace injuries, whether physical or psychiatric, his claim is preempted by defendant's participation in the Ohio Workmen's Compensation Fund. Upon review, the court agrees. Revised Code 4123.512. God, you know what? The Ohio Revised Code, just the way it's set up, drives me nuts. Maybe it's because I'm used to, I understand Florida statutes and, the Mississippi Code of 1972. Mm-hmm. Yes, that's what we call it, the Mississippi Code of 1972.
Yes.
That's just our last major revision was in 1972. Mm-hmm. But just the way they do stuff, they structure the ORC just, it's hard for me to get used to, but again, they do stuff different up there. Anyway, ORC 4123.512 states, in pertinent part, the claimant for the employer may appeal an order of industrial commission made under division of E section, whatever. This is not a workman's comp case,
right?
So that doesn't matter. I'm not even going to read the rest of that section because this is not a workman's comp case. This is negligence. Period. Mm-hmm. Defendant argues to the extent plaintiff is alleging claim for intentional infliction of emotional distress due to safety concerns. That's not what I said. I didn't say anything about emotional distress. I said it created an unsafe work environment. Didn't say anything about my mental state on how, oh my God, these poor inmates, I'm afraid of them. Let me tell y'all something. The day I'm afraid of a convict is the day you ain't got to ask for them. I'll hand you my balls. There ain't been a convict, and I've dealt with some of the worst convicts in Florida, Mississippi, Louisiana, and Ohio. You know how many convicts I've faced down and backed down from? I've faced down many. I've pissed off entire dorms. I had 150 head of convict wanting to whoop my ass in an open bay dorm under direct supervision in Angie, Louisiana, and I still never backed down. Because I enforce the rules.
At least that's how it's supposed to go.
Right. I don't back down from a convict. One at a time or all at once. You can have another riot like Lucasville. You know what? I'm going to talk about Lucasville later. Remind me of that. Remind me to talk about the riot at Lucasville. Because shit like this is what causes that. Anyway, I ain't afraid of no convict. Never have been. Never will be. In order to establish a claim for intentional infliction of emotional distress, a plaintiff must prove that the defendant intended to cause plaintiff serious emotional distress. The defendant's conduct was extreme and outrageous. I believe it was extreme and outrageous. And the defendant's conduct was the proximate cause of plaintiff's serious emotional distress. Never claimed emotional distress on any of this, by the way. Oops, what happened here? There we go. That's where I was. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Let's talk about this for a minute. Allowing an officer to be assaulted by a convict and doing nothing about it, I would argue is pretty fucking outrageous and atrocious. And I would argue that it is utterly intolerable. Generally, the case is one which the recitation of facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim outrageous. You're an average member of the community. You think this shit's outrageous?
This shit's fucking outrageous. I mean, human shit being thrown on somebody is just fucking outrageous.
As to the first element, as discussed earlier, there is no evidence to permit a reasonable inference that defendant intended for plaintiff to be harmed, emotionally or otherwise. Even if it could be inferred that defendant was negligent in some manner, no reasonable trier of fact would conclude that the defendant intended to cause plaintiff emotional distress.
They go with the emotional distress again.
Likewise, as to the second element, it cannot be inferred that defendant conduct was so extreme and outrageous that it was beyond all possible bounds of decency as to be intolerable in a civilized community. Gee, you wonder why inmates act. Oh. Although the incident involved human bodily fluids, the court must address defendant's actions, not the inmate. Plaintiff states that if defendant doesn't know how convicted felons will respond when you allow them to act contrary to the law, then I would argue that leadership of defendant isn't very good at their job. You think?
Yeah.
Yes, Annette Chambers Smith, I'm talking about you. You're not very good at your job. I knew that when I met you when I was at fucking Orient. However, defendant provided plaintiff a shower and a change of clothes before returning to his shift. Convict just threw shit on you.
Right.
Go take a shower and get a change of
Who wants
uniform.
to come back to that? No one.
You know, I had a CO, and I'm not going to mention his name, catch me in the parking lot that night. Before I left and I went to the hospital. Now, the first thing I wanted when I got off shift and I went to my car, the absolute first thing I wanted to do was calm down and smoke a fucking cigarette. After 16 hours without one, and that shit happening, I needed a fucking cigarette.
Yeah.
So I'm out by my car, and I smoke, and I light a cigarette, and this officer walks up to me, and he goes, "I don't know how you did it." I said, "You don't know how I did what?" He goes, "I don't know how you went back in there and worked." So what the fuck are you talking about? I had to do my job. I'm not showing weakness in front of convicts. I never have. Never. The closest thing to showing weakness that I think I've ever done was I was in extreme pain when I had my gallbladder taken out, and I was working at Stone County Regional Correctional Facility right there in Wiggins, Mississippi. And I hurt so fucking bad that I fell up against the wall when I was bringing convicts back in from the rec yard. I think that was the only time I've really shown any kind of pain or weakness in front of a convict. And that was just bodily reaction. I had no choice. I was in that much fucking pain. So I don't show weakness in front of convicts. Reason I don't show weakness in front of convicts, you can probably blame the guy that trained me. I think he trained me very well. That'd be well, I'm not going to mention his name, but he's down in Florida, and if he sees this, you know who you are, brother. Tip my hat to you. Moreover, defendants in-house investigators reviewed the incident, provided the report to the Ohio State Highway Patrol, at my insistence, by the way, and took institutional action against the inmate. Upon review, this court finds that none of the alleged acts by defendant rise to the level that a reasonable finder of fact would consider to be extreme or outrageous. Let me tell you what happened to that inmate, and I've said it in other videos, and I'll say it on this one. He got moved from a 4B wing, which is restrictive housing, to confinement or segregation. Sorry, spent too much time in Florida. You know how much his life was interrupted going from one to the other? It wasn't. He had the same privileges, with the exception that he didn't have his canteen in confinement. He got showers every day if he wanted it, 2 hours in the rec cage if he wanted it, his same meals if he wanted it. His life had zero interruption, and I'm going to tell you, I packed his fucking property. He's a state baby. He didn't have much canteen. I'm going to also throw this out there, and again, I cannot prove this, but this is what I was told by another CO. That was a hit on me. And what I was told, again, I cannot prove this, so don't take this as 100% fact, but I was told that he was compensated $150 by other inmates to throw shit on me. And $150 is a lot of money to this guy because he didn't have shit. Again, he's a state baby. Plaintiff's actual contention with the defendant is the defendant's failure to bring outside charges against the inmate, which, while conflicting with plaintiff's desires, is not outrageous given the facts before the court. How is that not outrageous? According to the extent alleged, plaintiff has failed to state a claim for an IIED which the court has jurisdiction over and must be dismissed. Failure to state a claim's negligence for failure to prosecute. Defendant alleges that to the extent that plaintiff seeks release for defendant's alleged negligence in investigating and prosecuting the inmate's conduct, he fails to state a claim upon which relief can be granted. Upon review, the court agrees. To prevail on a negligence claim, a plaintiff must prove by a preponderance of the evidence that defendant owed plaintiff a duty, that defendant's acts or omissions resulted in a breach of duty, and that breach proximately caused plaintiff's injuries. I thought I did with the videos and the fact that nothing's been done to this inmate. I would argue that I have more than the preponderance of evidence. And if you don't know what preponderance of evidence means, correct me if I'm wrong, Mr. soon-to-be law student. The greater than 51% of the evidence showing my favor.
That is correct. And yet every piece of evidence and put it right in front of their faces. It just shows incompetence.
So I would argue that I absolutely have the preponderance of evidence and then some. The duty element may be established by common law statute or by particular circumstances in the case. Plaintiff argues that defendant has every duty to prosecute every convicted felon in their custody who assaults any correctional officer or support staff of the institution. However, the Ohio Revised Code places such statutory duties as investigation and prosecution on other government agencies not a party to this suit. I'm sorry. Should I have put the Highway Patrol in there? Should I have put the Lucas County prosecutor in there? Because I can refile in federal court. Mm-hmm. And since you want me to name them, I think I will. Which is related to the investigatory powers and duties of the Ohio State Patrol, states that the superintendent or any state highway patrol trooper may enforce the criminal laws on all state properties and state institutions owned or leased by the state. RC 309.08, which is related to the prosecutorial powers and duties of prosecuting attorneys, states that the prosecuting attorney may inquire into the commission of crimes within the county. The prosecuting attorney shall prosecute on behalf of the state all complaints, suits, and controversies in which the state is a party. Moreover, such statutory duties allow for discretion in carrying out investigation or prosecution. There's that discretion. By its very terms, vests the State Highway Patrol on discretion to enforce criminal laws on all state property, state institutions. Upon review, the defendant does not have Sorry, give me a minute. Upon review, the defendant does not have a cognizable duty that could be breached in relation to plaintiff's claim that the inmate should have been prosecuted. Defendant provided plaintiff with the ability to shower and change his clothes before return to shift. Defendant's in-house prosecutors provided a report to the Ohio State Patrol investigators, as well as defendant imposed institutional punishment segregation on the inmate. As such, defendant does not owe a duty to plaintiff to further investigate or prosecute the inmate, which is a duty given under these circumstances to the Ohio Highway Patrol and or Lucas County Prosecutor's Office. Accordingly, plaintiff has failed to state a claim for negligence against the defendant in relation to the inmate not being prosecuted and must be dismissed. Conclusion. For the above stated reason, defendant's motion to dismiss is granted. Plaintiff's claim related to his workman's compensation is dismissed without prejudice. All remaining claims are dismissed with prejudice, and court costs are assessed to plaintiff. The clerk shall serve upon all parties notices judgment and its date of entry upon the journal. Lisa Sadler, Judge. So, let's talk about Lucasville for a minute.
Yes, I want to hear this one.
Lucasville, Ohio, 1993. You ever seen that show, Captive?
No.
Well, episode 1, season 1 of Captive shows the riot at South Ohio Correctional Institution at Lucasville, Ohio. The riot lasted 11 days. It was the longest prison riot in U.S. history.
11 days.
11 days. Several convicts were killed. One correctional officer was killed. 3 correctional officers were kept captive. They took over an entire dorm of the prison. And, by the way, fun fact, because the Ohio Department of Rehabilitation and Corrections is so fucking incompetent, even back then, their hostage negotiation handbook, guess where it was?
Where?
In that fucking dorm.
Jeez.
Where the inmates took over. Now, here's the beautiful thing about it. So when the hostage negotiators, in Florida we call them CNT, which is Crisis Negotiation Team.
Mm-hmm.
When the CNT people get on the phone with the inmates are looking at their playbook and they're like, yeah, we know what your next step is. Yeah, that's bullshit. You're not going to play this with us. We have your handbook right here. Try again. Now, you know I started my career in corrections in Florida, right?
Right.
I maintain that the Florida Department of Corrections will always be near and dear to my heart. Straight up. Always be near and dear to my heart. I was proud to work for the state of Florida. I honestly wouldn't mind going back, but I'm not moving back to Florida if I can help it. No way in hell when I worked for Mississippi, fuck Burl Kane. Refuse to ever work Louisiana again because they're just as fucked up as Ohio. But you would think Ohio would learn a lesson. You know why those convicts were able to take over? There were no checks and balances. Somebody didn't do their job. That's why that CO got killed. That's why those convicts got killed. So, they did all this. And what is Ohio's response? These poor inmates. No, excuse me. I'm sorry. You can't call them inmates. You can't call them convicts. They're incarcerated persons. Now I know you're a little left of me. you know.
They're
But
still inmates. I still call them inmates. That's what they are. Point blank, they're inmates.
no, up there, they're incarcerated persons because, you know, inmates is offensive. Convicts is offensive. The day I give a shit about offending a convict, you know, and I'm not saying to be an asshole. If you want to work corrections, I'm not saying be an asshole. I'm saying go in there like you got some sense. You treat them like fucking human beings. I'll give you that. I'm not saying abuse them.
Yeah.
I'm not saying I'm all for brutality because I'm not. I'm not saying go in there and beat the shit out of them because I'm not in favor of that either. What I am saying is you fucking, when they violate the rules, you bring the fucking hammer down on them. You enforce the rules.
That's why we have laws. They maintain order. That's
Right.
how it's supposed to. That's how it's intended.
It's a fucking prison.
Yeah.
It's not supposed to be.
They're in there for a reason. They're convicts, convicted felons.
I thought they were in there for singing too loud in church.
You got a lot of black folks in there. A lot more than you already did.
Well, I mean, black, white, I don't really give a shit. Hell, honestly, truth be told, I've had more problems with white inmates than I have black inmates.
Wow.
The guy that threw shit on me was white.
This is a kick.
Most of the inmates I had problems with in Florida were white, especially down in Miami. Because they saw me, you know, the Mississippi redneck, and they thought, oh, well, hey, we got a white boy here. We can get a... Sorry, homeboy, I don't give white privilege.
Andy does not like that.
Matter of fact, I actually used to tell inmates that, you know. I'm gonna give you a true story. I was down in Miami. I was working Everglades CI. I was working an overtime night shift, and it was right when COVID was at its peak.
Oh.
So I'm in a special housing unit. Well, it was a general population unit, but they were 2-man cells. So it wasn't like open bay dorm. They were on quarantine for COVID. Out of 1,800 head of convict, I think 700 were on quarantine at this time. Because if one person got COVID in the dorm, the whole dorm was on quarantine. Whatever. So I let this guy out to get a shower, and he goes over to another cell and starts talking to his buddy. I'm like, dude, get in the shower or go back to your cell. It's that simple. Well, he blows me off, and then I'm like, dude, all right, you know what? I've given you an opportunity to get a shower. I've got the rest of this quad to shower. Go back to your cell. Well, he goes and jumps in the shower. And I thought, okay, well, I got something for you. He gets out, I cuff him up, I take him to the captain's office because I'm fixing to lock him up in confinement. And I looked at him and I said, you know, you must think I'm some whole other body. I said, I'm going to tell you, I said, I gave you an order, or you want a bus. I said, I don't give white privilege. Your white privilege card is fucking non-existent with me.
Mm-hmm.
And he goes, well, you're right about that with these coons in here. And that's exactly what he said.
Wow.
Oh, you going to play that game. Well, I took him to the captain's office. And captain wouldn't let me lock him up. Okay, whatever. I take him back to his dorm, take him back to his cell. He got a black cellmate.
Jesus.
I look at him, I said, oh. I said, so you can't get ahead because of these coons in here. I said, you got a black bunkie. Is he a coon too? Y'all have a good night.
Good God.
I let the trash take out itself.
He probably got everything he deserved.
Well, I don't play them stupid ass games. Racism has zero place in a prison. Zero.
Yeah.
It has no place anywhere, but it really has no place in a prison.
Mm-hmm.
You treat everybody the same.
We're all locked in there, not just the blacks. Or
everybody.
All y'all are up in there.
I don't care what color you are, where you from. I don't care what your fucking crime is. I'm treating you the same. Now, I say that to say this. Are there inmates that I actually run into that I just think that they need to walk up to the nearest tree and apologize for wasting oxygen? Abso-fucking-lutely. Some of them need to carry one in their pocket and apologize to it at least once every 30 seconds for wasting its oxygen. Did I run into some inmates that if I would have ran into them on the outside, I'd probably be drinking a beer with them? Yeah. You know, some of them, you know, they made a mistake. They seem to be all right. They're not like ultra pieces of shit. You know, I run into some that I like. I run into some that I just cannot fucking stand. Mm-hmm. But I treat everybody the same, and I enforce the rules equally across the board. If you don't, you're fucking wrong. State of Ohio, they want to coddle these motherfuckers. You do not lower recidivism rates. You do not keep the public safe. You do not punish violations against state law by coddling these fucking convicts. Convicts are master manipulators. And they don't give a shit about you. And they prove that every day. And if you think I'm joking, keep doing what you're doing. Every one of y'all that work for the Ohio Department of Rehabilitation and Corrections need to quit. Every one of y'all. If this doesn't show what the state of Ohio thinks about you, this case right here
sets a precedent for the whole state, the whole administration, all of them. It tells you exactly how they feel.
Right.
It's a slap in the face.
They don't give a shit about you.
Yeah.
But let me tell you what they do, what they will do. You got that snitch box in the middle of your chest. You're taking abuse every day. Convicts calling you everything but a child of God. You have to take that abuse and be professional. Yeah, okay, I get that. We're human. We're human. You get up in there and you have to listen to it every once in a while, you're going to wind up and just look at an inmate and tell him to go fuck himself. You're wrong. You're getting written up. You could lose your job. And what's the inmate get? Nothing. The Ohio Department of Rehabilitation and Corrections does not care about your safety. The snitch box that you got right here, that body camera, that's to hurt you. That's not to defend you. If y'all don't see it, I don't know what to tell you. I can't. There's not enough neon and a big enough billboard to put in front of your face to get this point across if you don't see it.
This should be everything you need.
It's every fucking thing.
Yeah. And I would encourage others to come forward with information.
Please.
Because this is a major problem.
Because now I get to go federal. I'm prepared to fight. And since I can't find an attorney with any balls in the state of Ohio, I guess I'll do it my damn self. I'm done playing. Oh, and if you think the OCSEA, the fucking union, is going to back you up, keep that faith. OCSEA ain't backing nobody up. They're worried about kissing the state's ass. They don't give a shit about you. None at all. Y'all have a good night.
Peace out.